But the boxing of someone in with your vehicle, and I read the PSI report, and I read the stipulations. In the stipulations, the driver of the vehicle said, "Hey, my son is in the car." And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, "Oh my gosh, shucks, I didn't know there was a child in this car. Let me pause." But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court.
Isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah. So, state, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Miss Franklin. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted responsibility for a robbery here in Berke County.
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17.
And when did she turn 18?
November 3rd.
And where is she a student at? She, made future plans, applied to any universities, or done anything at this point in her senior year?
Yes, she was accepted to UTSA, and we're pending.
Excuse me, please whisper.
Say it again, ma'am.
She was accepted to UTSA, and we're pending the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's doing good. She's on my honor roll. Right now she has all A's and perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer to the court today?
She did.
Ron, I tendered this to the state for their review. At some point, you'd like me to look at that, Judge.
All right, any objections to the court reviewing this? All right, you may continue.
Ms. Franklin, with regard to that letter, is it a positive review of?
Yes, Michaela's right now, since her release, she's at the best she's ever been. She's focused, she's serious about furthering her future for college, and she's on the right path.
I'd like to take you back to, I guess, the time around this offense. And before I do that, I want to ask you, are you a single mom?
I am.
Does Michaela have a father in her life who's active, or?
He's not active, not consistently.
And does she have any siblings?
She does. She has a brother and a sister from her father.
But living in your household is just
No
you?
one, just me and Michaela.
I want to take you back to around the time of the offense. Do you remember getting a call that Michaela had been locked up for some very serious offenses?
Yes, I do.
And can you tell the court what your response was?
That she needed to sit there. I left her in there. She needed to understand what she had done and take responsibility. I left her in there for 5 months before I bonded her out, so she could understand that she didn't do anything, it wasn't something small. She needed to understand exactly what she did and what she could look forward to. She needed to know what prison or their county was, what jail was.
And do you think those 5 months had a significant impact in her life?
Most definitely. I know for a fact she doesn't want to go back. She definitely has a true meaning of what jail is.
And was that your goal at that time?
That's definitely was my goal, because I could have bonded her out the same day or the next day. I mean, I could have got the financial means to get her out. So it was definitely my goal for her to learn her lesson. And hopefully we don't ever have to revisit this again, which I don't think we will. I honestly think that she did learn her lesson.
Miss Franklin, let me ask you, at the time when she was arrested, were there some behavioral problems that you picked up on?
Yeah, there was, but I thought she was just being a rebellious teenager. I didn't realize she was like depressed and had low self-esteem until she had suicidal thoughts. I took her to Little Ridge, but they let her out and she did a little counseling here and there. So I thought she was just being more rebellious to herself. I honestly didn't know it was mental health issues there. But once I did know, I've gotten her help.
What mental health issues have you discovered regarding Michaela?
Definitely depression, low self-esteem. We've been going through exercises with the counseling sessions. And me, myself, just trying to boost her up and get her on the right path to feel good about herself.
And do you think you're on a positive path right now?
Most definitely we are.
She's back living at home?
She lives at home. Our relationship is really good. She's more open. We actually have conversations about how she's feeling. And I think we're on a really good path.
And that's different than what it was before the.
Most definitely. She would stay to herself more, so lock herself up in her room. Just for me, what I thought was normal teenage stuff, but evidently it was a little deeper than that.
Ms. Franklin, you own the business. Would you tell the judge what you do for a living?
I do. I'm Share Glamour Salon, a hair salon in San Antonio.
And have you and Michaela talked about her interest in working in the salon?
Yes, but actually before this, she did. She was my assistant. And to be honest, I need her back as an assistant, but she wants to be a barber and to get her through college. It'll be something for her to fall back on. And I can, I'm also an instructor, so she can get some of her hours through me.
You mentioned that she's been accepted to UTSA.
Yes, she's been accepted to UTSA, but she's also, we're pending the application for Clark Atlanta, which she preferably would want to go.
And what would be her interest in studying in college?
Business marketing.
So you left her in jail for 5 months and now she's been on pre-trial release as a condition of her bond.
Correct.
I know we had one GPS circumstance that we had to take up with the court, but
yes.
Other than that issue that was straightened out here in the courtroom, do you think she's been compliant with all the rules?
Yes, she's been compliant. And I also make sure she's compliant. I mean, we get home on time, way before time. We don't take no shortcuts. So yeah, she's definitely compliant.
I know that today we had the opportunity, the three of us, you, me, and Michaela, to go through the pre-sentence report. You can see there are some pretty raw feelings on the part of the listed complainant.
Yes.
Can you tell me if you think, even before today, do you think Michaela recognizes just how serious this offense was and the fear that people were placed in and the after effects of that fear?
Yes, she definitely recognizes that. She's definitely voiced how remorseful she is for this. I know for Christmas we did, she wasn't able to actually go to the battered women's shelter, but she did produce a toy drive. So where she marketed it and we received a lot of toys, I think over 500, and took it back to the battered women's shelter. She definitely is remorseful and she definitely understands that she put these people in fear and it's not to be taken lightly.
Very good. Could you address very quickly whether you think your daughter would be a good candidate for probation or deferred adjudication in this court?
I think she would be a great candidate. I think, matter of fact, I know she has a bright future. This was something that she got herself into that I know she regrets. And I don't think that she should be sent to jail. She's done 5 months. And I understand that it's not the same as 10 years, but she definitely recognizes and has had a taste of what jail is to not do this again and not be in any more trouble and to succeed and hopefully help other juveniles and help other people who are going in that direction.
Ma'am, that's all the questions I have. The
Okay.
state has an opportunity to ask any questions they want.
Yes.
Any questions?
Were you aware that this offense occurred on February 8th of 2023?
Once I got a call from the Michaela when she was already in custody.
So you knew the date.
Yes,
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was Wednesday?
I mean, I don't know.
It was a Wednesday.
Yeah.
Would it surprise you that this offense occurred shortly before 1 p.m.?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So do you know, or did Michaela ever talk to you about what happened during this offense?
Yes,
So you were aware that the victims in this case was a mother and her young 4-year-old son.
yes, sir.
And you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of the case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here.
I don't think it would be appropriate for Michaela
And ma'am,
for the simple fact.
I'm gonna ask if you could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir.
Is it understandable?
It definitely is understandable.
And were you aware that the other two people that participated in this act, that they were both younger than you?
Yeah,
So she was the oldest one out of the group, right?
okay, yes.
So she should have been able to make better decisions than the other two, correct?
I don't agree with that. The other two had been in trouble, I understand, and she also was the only girl. So,
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver, yes, sir.
Specifically that boxed in the victim and
I
her son.
understand.
Nothing else to say.
All right, any other questions?
Ms. Trentham, I think I tendered it to the judge as a part of the other letter, but we did take Michaela to be evaluated by Mark Harris. Is that
I
correct?
did,
He's a licensed therapist, is that correct?
yes.
Judge, if I didn't give you that.
Yes, you did. And I reviewed it.
Okay. very
It's
good.
attached to that.
Thank you, Judge. And you had the opportunity to look at his assessment, and that's helped you on a path of understanding her now, is that correct?
Yes, it did.
All right. Thank you.
Yeah.
Thank you for coming in. All right, defense, call your next witness.
Judge, that's it.
All right, did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right, so I want to let the parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure. That was
But
me.
then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
And I think we addressed that actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of a process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that contrary to what the state wants to put forward is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun. So I think as to Miss Ballard's point in the PSI, maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right. Anything else from the state?
I was informed by Berke advocates that the witness on Zoom was dressed. It was a brown sweater. That's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge. I just wanted to make sure.
All right. Thank you. All right.
I don't want to overstep, but I do want to make a brief argument next time.
Yes, you may proceed.
So, Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get out of jail? I think Ms. Franklin took a very brave approach for a single mom, and that is that I want her to sit there. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by. And so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from really doing well in school. It's far for me to believe she's 17 years old when I met her and charged with such a serious crime. And she's turned 18 and she's only, 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this, because we've spent hours talking about the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris, and Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. He specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction and being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path, and we'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what she's gonna have to make going forward. It's something that the state feels that prison would be appropriate here. The victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think have the more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation,
Mhm.
and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Berke County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway the court in giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem, and what I think people need to look at. Sometimes punishment, and all attorneys will tell you, when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report, and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court—
Isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So and I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is bothered me, I knew I'd seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing them in. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is.
Well, I don't think it's her feeling. So it's not going to be in a police report.
Right.
But I can tell you that was her feeling on this. She did feel threatened by these 2 young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
No, Your Honor.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, Grand jury number 806632. There's to be restitution of $110 to John Bright and credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right. Irene Hernandez, who was placed on deferred adjudication in 2020 CR 8599 for the offense of abandoning a child with intent to return on January 4th, 2021 for a period of 3 years. Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violating condition number 13, on or about the 23rd day of April 2024. In Berke County, Texas, defendant Victoria Hernandez did then and there operate a motor vehicle without a valid Texas driver's license in violation of condition number 13.
How do you plead to that? True or not true?
Waive the remaining violating conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 13, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand that?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 13?
I do.
Court will find violation of condition number 13 true. Is there a proposed agreement?
No, there's not.
All right, state, what are you requesting?
State's requesting revocation.
Defense, what are you requesting?
Your Honor, probation had made a recommendation to extend for 1 year placement Ms. Hernandez in a DDRF, followed by mixed supervision and a parenting class. And as the court could see, she was in felony drug court. DDRF was held in abeyance last time as an option, and she is motivated to go to DDRF, be successful in it. Apparently the wait is only 3 to 6 weeks, and that's what we're asking the court to do.
All right, any objection to the court reviewing the court summary?
No objection, Your Honor.
All right, Ms. Hernandez, I don't think you're a good candidate for probation. And let me just tell you why. Felony drug court is an intensive form of probation. I know that. But from reviewing the court summary, it's not as though felony drug court, you mess up one time or you make a bad choice one time that they say, oh, we're not going to deal with you anymore. And I'm looking here at the sanctions that they gave you over there. And let me just tell you how many sanctions they gave you, which means this is how many chances they gave you. You understand? So it's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36. That's what you're coming to this court with. 36 times felony drug court was seeking to work with you. So you see where my mindset is? And do you understand why?
Yes, Your Honor.
And so I placed you on probation here. And even here, you had a motion to revoke filed against you. And that was on, well, it was heard on March 9th, 2022. And that's when you were sent to felony drug court. So I don't think you're a good candidate for probation.
Judge, if I could,
Yes.
one thing for Ms. Hernandez, the good thing about felony drug court for her was that it is our belief that it has worked. She has been clean since September, and if she was tested today, she's going to come up negative.
Mhm.
So, it's not like she totally, yeah, there's several things that she did do correctly in felony drug court. There are a number of things, obviously, as the court has seen, that weren't done correctly, but she's made a lot of her appointments and, she has ended up clean, which is the point of felony drug court.
I just don't think you're a good candidate. I mean, felony drug court, that's a very good program. And what felony drug court has placed, you know, the issues they have with you. I mean, they're major issues, but instead they are still trying to work with you. And they tried to work with you a lot. Here's the thing. I know a lot of people want to stay on probation. They do. Like nobody wants to go to prison. I don't take any joy in sending the people to prison. And everybody that I send to prison or everybody I place on probation, I actually do remember them. Even as a defense attorney, I had some clients who ended up in prison. Guess what? I still remember them and wondering how they're doing and hopefully they've changed their life. And it'll be the same with you. I just don't think you're a good candidate for probation. I think we tried.
And
So,
And Judge, the only other thing is she's never been given a felony conviction before. That's why she wants to stay on defer. She's motivated for it. And that's why she was hoping that the probation's recommendation would be followed.
all right, this is what I'm going to do. I'm going to find 13 true. I'm going to revoke, find you guilty, and I'll sentence you under 1244. Does anybody want to state any objection to her being sentenced under 1244? All right, I'll sentence you under 1244. Let's talk about the time.
Yeah, how much time does she have? Anybody know? How about before all the past 3 years?
Judge.
Yes.
So I was going back and forth with the drug court personnel in this case. And there is some concern if she is given a sentence JSAT.
Oh, it's not going to be JSAT.
Okay. Okay.
All right. And what was the concern though? Now you've piqued everyone's interest.
Judge, they feel that a JSAT sentence is not the reason why she was kicked out of drug court and so forth. They just don't think JSAT would be appropriate. And some other concerns in regards to her child. So if she was given JSAT, they just have concerns in regards to that. Now, if she was continued, then that would be something different, but they are not in agreement with anything JSAT.
All right. So what is the issue with the child?
From my understanding, there is a CPS open case for neglect and possible abuse.
Not on me, on the father.
Okay.
There's an open case.
And state you're asking for revocation?
Correct, Your Honor.
So we are not opposed to revocation, but we are not with JSAT.
Okay.
Judge, if
I mean, what I can tell you, I wasn't going to give her judgment satisfied. I just, let me just tell you what my thought processes were.
Yes,
My
Your Honor.
thought process in reading everything was I saw that there's a child involved, right? This case involves a child and it's abandoned with intent to return. So I understand, and I understand that that child, they're telling the report is special needs,
Yes.
but she's making horrible choices.
At the same time, Judge, if she goes to DDRF, it doesn't kick the can down the road. It puts her in a position where potentially she'll be a better citizen, better productive parent. So DDRF only lasts for long, probation only lasts for long. If we help her continue, she has a possibility of, one more chance. And the court has given plenty of chances before, but if she's given one more chance, there's a possibility that one day she's going to be still with this child, and that child needs a stable parent, and DDRF will help in that potentially.
State? Is the state still recommending revocation?
Well, Judge, little of child involved, I mean, the state would be opposed to DRF.
We'll tell you what. Your special needs child has saved you. and you're not saving your special needs child. So where's the child now?
He is with his father at the moment. The CPS case is on the father and the current girlfriend. And
So let me get this straight and correct me if I'm wrong. So you are saying that there's allegations of abuse, and those allegations are abuse against the father who he's with?
yes, Your Honor. And the case has been open for about they opened one CPS case, my court did, because of the what they had found in my phone. And then the caseworker got in touch with
What did they
with the
find?
father.
Wait, raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth?
Yes, Your
So
Honor.
help you God.
Yes, Your Honor.
All right,
So
state your name.
Victoria Hernandez.
What did they find in your phone?
So they found that, so I had found out that my kid's father was locking my son in the room, and I wasn't aware, like I had, like, so later on, they said that it was because like the autism doctor recommended that they lock the door at night, but I thought like they were just locking my son in the room like all day. And so that's what drug court found on my phone when they were going through our messages, was me like getting mad at the dad about locking my son in the room, and so they called CPS for neglect. And then the dad got another CPS case because I believe the school called CPS for neglect as well.
All right, any objection to somebody from drug court zooming in?
No objection.
All right, just have a seat. Drug court is going to zoom in so we can get to the bottom of what's going on. All right, we're back on Victoria Hernandez. Hi, Officer Garcia.
Hi, Judge. How you doing today?
All right, how are you doing?
I'm great.
I miss you guys.
We miss you too.
Okay. All right, Miss Hernandez, if you'll come down. All right, so we have Officer Garcia by Zoom. Any objections to her being by Zoom? Defense?
No objection, Your
All
Honor.
right, and the state has already stated that they do not have any objections. Officer Garcia, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Do you waive any confidentiality that Ms. Garcia has as it relates to your time in felony drug court?
We're talking about.
Oh, no, I don't mind.
All right, so you're giving up that right.
Yes, Your Honor.
All right. Any objection to her testifying in the narrative?
No, Your Honor.
All right, Officer Garcia. What we're trying to discover is whether or not she should be revoked or whether or not I should send her to DDRF. What has transpired is there's been a mention of a child with special needs, because I was inclined to sentence her to the Berke County Jail under 1244 to 1 year. Can you tell us how she was doing? What have been the issues with her in the drug court, and what would be your recommendation for her?
Judge, Victoria was on my caseload the entire time that she was in felony drug court. As you saw in the court summary, we did work with her extensively. Every time there was a violation, we used progressive sanctions. We did have DDRF in abeyance, back on 9/20/2023. Instead of that, we went ahead and gave her the chance to do Alpha Home, which she did complete. However, she went right back to her old criminal thinking. People, places, the basics that we teach in felony drug court. We were working with her, and we happened to do a phone search only because there was another phone search done on another participant, kind of intertwined the two. And that is the only reason why we found out, is like it fell into our lap. It wasn't something that we were looking for. And we had concerns, again, because of her special needs child. We do have another case against her in CPS. So the CPS case, there is one pending for her, the father of her child, and we do also have one for herself.
All right. Do you know, with regards to the case for herself, what is that about?
Because of what was found on her phone.
Ah. So what was found on her phone has absolutely nothing to do with the child's biological father?
It's actually both of them are involved. But again, he was the only one that the case had, the first CPS case is only on him. So when we found the information that included both of them, a CPS case was filed against her as well.
So what was on her phone? Did it have to do with, I don't want to get into too much, but what was on her phone? Did it have to do with her as it relates to her and her child?
Yes, concerning for her to be around her child, absolutely.
Okay.
And then considering her case that she's on as well. So with that being said, we have seen often that we work with the individuals and there wasn't really enough progress and we don't feel comfortable with one, probation doesn't like to recommend revocation. But we have seen in drug court that a lot of our participants are getting credit for time served. So we didn't want her to just, get a JSAT and be done, because then there's no problems that are fixed. And then we have the concern for the son, because she will be able to go back and just be around him. That was what she was trying to do while she was on my caseload. So that is very concerning. If I could recommend revocation without the JSAT, I would. And I would like to. That's what I would like to happen.
All right. Do you have any questions?
I do, Judge.
All right.
Officer Garcia,
Yes, sir.
throughout her time throughout felony drug court, she tested negative on multiple occasions, correct?
She did. However, she also tested positive.
How long ago was that?
Let me check. Drug test. Well, she did have a no-show, so to us, that was April the 17th. That is considered a positive in felony drug court. Let's see, her last positive would have been September of last year.
2023?
Yes. And again, she did go to treatment during that time frame before we just got her back reporting in person.
That's all I have for you. Thank you.
Mhm.
All right. And Officer Garcia, you all are not willing to accept her back. Is that correct?
No, Judge. We worked so much with Miss Victoria, and it just seems like we hit a wall at this point.
All right. Thank you so much for zooming in on such short notice. I appreciate it.
Yes, Judge, you have a good rest of your afternoon.
Okay. All right. Bye-bye.
Bye-bye.
All right. So with her, it's going to be revocation. Are you still insisting that what was in your phone was not related to you?
I wasn't aware the second time around that a CPS case was put on me. I've been in jails.
No. My question is,
It
are you
is-
still saying that what was on your phone regarding your child is unrelated to you?
No.
Okay.
Judge, in lieu of that, we're asking for the minimum time in law. Apparently she has 158 days in custody over the past 3 or 4 years. And I would argue that, she has done several things right. She's also done several things wrong, but there was several things. She did participate in the felony drug program and did a lot of good things. So we want the court to reflect on that.
All right. This is what the court is going to do. Court is going to revoke you. Let me see. Where is the trial court certification?
Handed it to the court.
I do have it here. The court is going to revoke you. The court is going to find you guilty. The court will give you credit for any time served. The court will give you credit if you successfully complete an inpatient treatment, because I see There was some inpatient treatment, maybe through Alpha Homes. If you successfully completed that, the court will give you credit for that. And the court is going to sentence you to 2 years in the state jail facility. I'll recommend the therapeutic community. I can't force them to place you in there, but if you request it, they will consider it. If you don't request it, they will not consider it at all. And I'll also request mental health while she's at the state jail facility. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're going to have to get your life in order. If you don't, your life is going to continue to spiral out of control. Felony Drug Court is a good program. They work with you for 2 years trying to help you, and you still just want to do whatever you've been doing, which is not good for your son. I always tell people you're an adult. Your son is not an adult. Your son is 100% dependent on you, upon you, and you're just doing foolish things. Good luck to you.